might include rent on temporary accommodation, removal cost, extra running cost, and so on. They are generally set as a fixed daily or weekly sum, although there may be more complicated formula where the works are phased, where may be partial possession, and so on. It is important that the method of calculation is precisely and formally documented. The Qatari court rendered judgments which approve the liquidated damages as seen in cases where we have seen as the lawyers that submitted to the Qatari court. Liquidated damages calculations might include, amongst other things, loss of rent, loss of income, the fees, the storage cost, the rental cost, fees and fines imposed by third parties, and finance cost. This is the end of my introduction, and I am very keen to hear more from my colleagues, Mr. Ahmed Habib and Mr. Abduljabbar Saifuddin, with the final remarks by Professor Mohamed Abdel Wahab. Thank you very much.
Thank you so much, Dr. Nasser. I will invite Ahmed to start his first part of this webinar. Please, Ahmed, the floor is yours.
Thank you, Saad, and thanks to Ciarb and AACE and all the speakers and Dr. Nasser AL-Adba for the preparation and the organization of this event. I'll start the first presentation on liquidated damages in construction disputes. And the subject today is particularly interested to see what is the meat and the reality of the sought predictability. So I'll now share the presentation. Okay. My presentation will touch particularly upon the following questions. First, I will try to explain what is the question and the definition of liquidated damages for those who are not very acquainted with the concept itself. Then I will address how common are they used in practice, and then what is the purpose and the rationale and the idea behind the use of liquidated damages. Then I will turn to how these liquidated damages are actually perceived in comparative law, how they are applied, whether they are applied or not. And then I will finalize my presentation by best practices and final remarks on liquidated damages so that everyone can try to get the best out of liquidated damages when they include them in the contracts. I will try to be brief on the very first questions about the definition and how common and the concept itself, because the organizers wanted to lead by example, so they made me sign a liquidated damages clause. If I deliver late my presentation, then I would be subject to liquidated damages. Okay, this was just a joke. So liquidated damages clauses in construction contracts. What is this? What is the definition of that? These are clauses reflecting a fixed rate agreed in advance by the parties to compensate the employer if there is any delay from the contractor in delivering the works in the time precise, the time of completion precise in the contracts. These clauses often reflects a daily rate, which is mentioned in the contract itself for every day of delay from the agreed day until the completion day, the real completion day. Generally, they mention a cap, which is serving as a limitation of liability clause. And commonly, this is by reference to a percentage of the price of the works mentioned in the contract. So it would, for instance, say that liquidated damages would be 100,000, let's say, per day, and it would be limited to 10% of the price of the contract. How often would we find them in practice? Actually, liquidated damages are very, very common in practice. Most standards form of construction contracts provide for liquidated damages payable upon late completion. For example, sub-clause 8.7 of the 1999 FIDIC Red Book provides in part as follows, and I'll quote it: if the contractor fails to comply with sub-clause 8.2, which is the time for completion, the contractor shall subject to the employer claims, pay delay damages to the employer for the default. These delay damages shall be the sum stated in appendix to tender, which shall be paid for every day which shall elapse between the relevant time for completion and the date stated in the taking over certificate, which is the real time of completion, as we said. However, the total amount due under this subclause shall not exceed the maximum amount of delay damages, if any, stated in the appendix. So here also in this FIDIC model, there is a limitation of liability to a certain amount as a maximum amount. Okay, now that we saw that is very common, the question is, what is the rationale behind the common inclusion in contracts? Why do we include them quite often? This is for certainty and predictability. So both co-contractors, basically the contractor and the employer, would be interested from the very beginning of the contract to have some predictability about what would be the exposure in case the contractor does not finish the work in time. The employer on this basis would calculate certain compensation of its damage, and the contractor, when pitching for the project, would know what would be the exposure that it would have if it does not accomplish the work on time. The second rationale would be to save time, effort, and cost of proving loss whenever there is delay. Basically, whenever there is, in any contract, whenever one would like to make a claim for breach of contract, one would need to prove three things: that there is a breach in the contract, that there is a harm or a loss, and that there is a causal link between the breach and the harm. In such case of liquidated damages, actually, the employer would need just to prove the breach, which is the delay, without the need to prove that there is a harm and the causal link, because this would be just by application of the liquidated damages clause. And this is the very idea of the liquidated damages clause. Okay. We understand the rationale behind the common inclusion in contracts, but do we really achieve these purposes by including liquidated damages in contracts? The answer actually depends on whether the liquidated damages are applied or not in every jurisdiction under every law. So the answer of whether we achieve these purposes depend on the legal regime applicable to the clause itself, whether they are considered valid or not, these clauses, whether the arbitrators or the judges are bound by the agreed fixed rates or could modify it. In order to give you a view about whether they are, how they are treated and whether we can achieve these purposes, we'll make a common law presentation, but to summarize one. So in comparative law, we can make a distinction between common and civil law. Generally, common law courts validate or invalidate the clause, but when validated, they do not interfere with the agreed amount, meaning their position is either black or white. They would validate it and then they would apply it as it is exactly with the agreed rate, or they would invalidate it and then they would go to the normal process of assessment of the loss. The criterion on which they decide whether to validate or invalidate the clause is whether it's considered as an estimate of the loss or as a penalty. If it's an estimate of the loss in advance, then they validate. If they consider it as a penalty, i.e. a punishment that was put in advance in the contracts in order to push the contractor never to delay, because if not, he would be ruined. In such case, it's invalidated and we go to a normal assessment of the loss. Under English law, a case law from the UK Supreme Court in Cavendish Square Holdings BV, rendered 2015, considered that courts are mandated to balance the provision against the legitimate interest of the party seeking to enforce it, or alternatively to consider whether there is a commercial justification for the clause. That's the position of common law. In civil law, the position is quite a bit different, as we are usually acquainted with some differences between the two systems. In civil law jurisdictions in general empower the arbitrator and the judge to enforce or not the liquidated damages, but as well to modify the agreed amount in certain circumstances. Let's have a focus on civil law jurisdictions in the region. So in the region, we can distinguish between two main schools. On the one hand, a position taken by Qatar, Egypt, and Bahrain, for instance, and on the other hand, a position taken by Jordan, Oman, and the United Arab Emirates. Under the law of Qatar, Egypt, and Bahrain, in principle, liquidated damages is valid and enforceable. That's the principle. Yet, these laws empower the arbitrators and the courts not to enforce the liquidated damages if there was no harm. This is the first exception. If the contractor can prove that the employer had no harm from the delay, then the liquidated damages clause wouldn't be enforced. The second exception would be the decrease of the amount of liquidated damages, and this would be whenever it's considered to be grossly exaggerated in comparison with the loss actually suffered. In Jordan, Oman, and UAE, those jurisdictions entitle as well contractual parties to agree on liquidated damages in the contracts as a matter of principle. But still, they empower the arbitrators in all cases, if requested by either one of the parties, to entirely disregard the liquidated damages clause and assess the damages as equal to the actual loss incurred by the employer. So basically, the law itself provides for or requires that the parties agree whenever they execute the contract on liquidated damages clause, but as well whenever there is a dispute, none of the parties, if one of the parties just requires that an assessment of the damage, then the liquidated damages clause would be disregarded. Let's now focus on Qatar law and the relevant provisions. Liquidated damages under Qatar law are governed by Articles 265, 266, and 267 of the Civil Code. Article 265 entitles the parties to agree on liquidated damages on the very principle. So I'll quote in what can be translated as follows: where the subject of the obligation is not payment of money, the contracting parties may calculate the amount of damages in advance in the contract or in any subsequent agreement. Then the very idea of the agreement in advance on the fixed amount is validated. Article 266 provides for the exception for the application of these liquidated damages clauses. So they allow their non-enforcement or the reduction in certain circumstances. And I'll quote, no agreed indemnity shall be payable if the obligor prove that the obligee has suffered no damage. The court may decrease the agreed amount of indemnity if the obligor proves that the calculation is exaggerated to a considerable degree. And here it's important to see that the law didn't provide only exaggerated, but required a certain intensity or degree in this exaggeration to a considerable degree, or if the obligation has been performed in part, any agreement to the contrary shall be invalid. And the fact that the law provides that any agreement to the contrary shall be invalid means that these exceptions are of public policy and that the parties cannot actually opt out of these exceptions by agreeing to liquidated damages without any exceptions. If they do so in the contract, it would be invalidated. And Article 267 allows liquidated damages clauses to be used as a limitation of liability, as we saw in the beginning, with saying that it cannot exceed a certain amount of the contract or whatever, but except in cases of fraud or gross negligence. In such cases, the judge is allowed and the arbitrator is allowed actually to assess the real loss and to compensate the party for the real loss, even if it goes beyond the limitation of liability and the liquidation of damages. Okay, these provisions in a nutshell to be presented would be as follows. When delay occurs, arbitral tribunals and judges enforces liquidated damages. That's the principle. unless in 3 exceptions. The first one, whenever the obligor can prove that the obligee suffered no damage, in this case, the liquidated damages will be disregarded. Second exception, whenever the amount of the liquidated damages is grossly exaggerated, or the obligation has been partially performed, and in these cases, the arbitral tribunals are entitled to decrease the amount to reflect the part that was not performed if there was a partial performance, or what would be not grossly exaggerated but a reasonable amount. And the third exception, whenever the real damage exceeds the amount of liquidated damages and the obligee proved that the delay is a result of the obligor's gross negligence or fraud, and in which case the obligee may claim a higher amount than the amount of the liquidated damages. Okay. What is the application of these provisions in case law in Qatar? To give you a bit of practical view on how they are applied by courts. Take an example, 2 examples. The first one is of the Court of Cassation judgment dated 5 December 2006. It's a challenge number 770 for judicial year 2006. And in this case, the Court of Appeal actually has not enforced the liquidated damages because it considered that the contractor suffered no damage, which is one of the exceptions mentioned in Article 266 of the Civil Code. It considered this was a case in which the subcontractor delivered the works to the contractor with delay, but then the contractor was able to deliver the work to the employer without any delay. So on this very fact that the ultimate work was delivered to the employer without delay, the Court of Appeal considered that there was no damage to the contractor. And actually the Court of Cassation endorsed the Court of Appeal judgment in this respect, meaning it did not apply the liquidated damages in this case by application to that exception under the law. A second case is the Court of Cassation judgment dated 10 December 2013 for challenge number 210 for judicial year 2013. And in this case, the Court of Cassation partially quashed the judgment of the Court of Appeal. So the first one, Court of Cassation endorsed the Court of Appeal, and this one, it squashed the Court of Appeal's decision. And actually, the Court of Appeal has decreased the liquidated damages agreed upon in the contract, while the Court of Cassation considered that in this very instance, there was a delay and that the contractor has not proved that the employer has suffered no damage, or that the liquidated damages were grossly exaggerated, or that the contractor delivered the works partially, which would justify to reduce the amount. So since none of the conditions of reduction of the amount or decrease of the amount were present in this case, the Court of Cassation quashed the decision, decreasing the amounts, requiring that the liquidated damages be applied as such. Having made a presentation of liquidated damage in general, their definition, and then the rationale, how they are applied under common law and civil law, we need to get to what are the best practices in the application of liquidated damages. The first one would be actually to include liquidated damages in construction contracts is a good idea, even if they do not provide an absolute certainty, because they can be applied or not based on certain conditions as we have just seen. Still, handled correctly, they increase the legal and the business predictability and allow a more efficient resolution of any dispute in this respect. The second good practice would be to think at the same time about the law governing the liquidated damages clause. And for this, to get the legal advice that would allow you to think about the liquidated damages within the context of the applicable law. Thinking about the applicable law should be done at the phase of the drafting of the liquidated damages in the contract, and at the phase also of its execution, or whenever there is a dispute about the execution of the liquidated damages, in order to see whether it would be enforceable or not in view of the applicable law. A third very good practice would be to involve a quantum expert whenever we think about liquidated damages. And let me try to put it that way. People who are not acquainted with the practice of liquidated damages can easily think that if you have a contract providing for liquidated damages, it's a simple formula. You have a daily rate, you have a number of days of delay, you multiply both, it's done. You don't need a quantum expert. From the presentation that I've just tried to show you the context of application of liquidated damages, one can easily see that involving an expert from the very beginning for the assessment of the rate to be mentioned in the contract would ensure the applicability of this rate, because it would ensure that it wouldn't be considered as a penalty under common law or as grossly exaggerated in civil law, in which case they would not be enforceable as clauses. Whenever there is a dispute, involving an expert in the assessment of the real damage would give an idea to both parties to determine their strategy on whether to go with requesting the application of the liquidated damages as such, or requesting its decrease if it's considered as an exaggerated amount. Thank you for your attention, and I tried again to stay within the limits in order not to pay the liquidated damages that I signed upon for the other for the organizers, but then I can address any questions in the Q&A section. Thank you.
Thank you so much, Ahmed. Very much appreciated. So, of course, Ahmed, you stay with us to the end. Then we will be having more Q&As, and already we have started receiving Q&A. Also, welcome Dr. Abdul Wahab. So we will start with the second speaker, Engineer Abduljabbar. Ahmed, if you don't mind, can you cancel the share, or Engineer Abduljabbar can come please to the floor so we can start with the presentation. And also thank you, Ahmed, so much for highlighting the last part, the quantum expert. So we will leave it to the expert now, Engineer Abduljabbar, to speak about the expert matters, liquidated damages from expert point of view. So Engineer Abduljabbar, are you able to share your screen?
Yeah, let me try now that.
Okay, perfect.
Can you see it, my screen?
Perfect, perfect, yes. Okay, I will be in the back. The floor is yours.
Thank you, Saad. It's my pleasure to be in this English panel, and sincerely I appreciate Ciarb and AACE for inviting me for this webinar, for this presentation. And my name is Abduljabbar MCIArb, and my presentation will cover the following topics, following up on Ahmed's presentation. Again, for those attendees that may not be too familiar with the various delay damages involving construction or any other contraction for that matter, I will introduce just briefly some of the damages related to some of the risks that are involved in delay in completion of the work. The second topic is what I call the EOT, which is for liquidated damage. EOT, for those who are not familiar with EOT, is the extension of time dilemma. The third one, then we'll cover some common issues that normally encounter in the EOT assessment. This is being a presentation on liquidated damage predictability. With a focus on Qatar, I will, for those who are not familiar too much with Qatar's construction adjudication landscape, just briefly I will mention how construction disputes are normally handled. Then I'll just add a little bit, if I can. Ahmed already covered this, but some case law on liquidated damage from Qatar, with some perspective. And finally, some suggestions how we can suggest maybe enhance the enforcement of predictability, which is the theme of this presentation. Liquidated damages come in various forms for when there's a delay in completion of a project. Of course, as Ahmed also mentioned, Qatar Civil Law number 22, 2004 basically covers the bundle of articles from 256 to 268 coming under compensatory performance. They cover the liquidated damages. So briefly, we have the delay liquidated damages, DLD. As was already mentioned by Dr. Nasser and Ahmed, this is a pre-agreed, pre-estimate of loss remedy before the breach of contract, meaning this was negotiated at the time of the contract, entering into the contract. And in Qatar, the customary liquidated damage has a cap of 10% of the contract value. And actually, this is there's a bylaw on this, number 16 for year 2019, pertaining to the public Qatar public tendering, and Turkish law number 24 for year 2015. It specifies it 10%. You might see also this liquidated and ascertained damages, which is basically is the same as delayed liquidated damages, but here, as we are talking about predictability, in liquidated and ascertained damages, the exact value of the delay LD is mentioned per day or per week in like CUR or in dollars per day per week. It's already mentioned. It's not left to be estimated or guessed. So these liquidated damages for delay is basically for a remedy for owner. But then the question always comes up, what if the actual delay losses are greater than the liquidated damages? So what other remedies are available for the owner? And this is, of course, we'll put some perspective on this. And then we have also what we call performance liquidated damages, PLD. This pertains to contracts which involves projects which have to process, like oil and gas, power generation, these things that have to, not only construction, you have to also, the contractor has to prove the performance. And depends on the complexity of these type of projects. It might involve multi-stage performance tests until the owner, the employer, issues the performance certificate. Now, normally PLD is triggered after the DLD cap out. So if there's a delay normally in this one, then DLD will be calculated, and once it reaches cap out, then the PLD will be triggered.
Engineer Abduljabbar, if you don't mind, can we raise the voice a little bit?
You cannot hear me?
I can hear you, yeah, but it's better to raise it a little bit. Thank you.
So unliquidated damages, how is it now?
Much better.
All right. Unliquidated damages, these are the damages that normally come after the dispute, after the dispute arises during the contract. So this is post breach of contract. It's not specified, pre-specified in the contract like liquidated damage. That's why it's called unliquidated damage. And this is basically is the remedy for contractor for things like prolongation and disruption costs and compensable termination, price escalation, change of circumstances that probably will provide some remedies for the contractor. Then there's also payment delay LD. In certain contracts, for example, clause 14.8 in the book, there is standard clause for interest and financial charges to be added to if there's a delay of payment. But it's not very common in Qatar construction contracts to have interest and financial added to payment. And this is normally a remedy for contractor, but what if there is no interest or financial damage, liquidated damages is specified in the contract? So what other remedies are available for the contractor? And hopefully we can add some perspective on this as we go through this presentation. Finally, on this damages definition, consequential damages. Now, this is the loss of the use of the properties and the loss of profit, consultant fees, direct and indirect costs. And as I mentioned earlier, what if the LD doesn't cover the loss for the employer? This consequential damages, which can be pursued after the liquidated damages has been capped out. And this could be potentially enormous risk for both an owner and contractor. And normally in the practice, this is through the limitation or waiver clause, except this applies, except when there's a fraud or gross negligence. Second part of my presentation is the LD and EOT dilemma. Now, in construction project, it doesn't really take long for a construction contractor to face an LD claim. Now, if you realize that, say, a 0.5% of contract value per day liquidated damage is only 20 days to cap out. And if you assuming 10% maximum cap, and if the liquidated damage is specified 0.2%, again, it's 50 days. It's not so long. So in a 2 to 3 year type contract duration, a contractor might face himself that within the first 7 or 8 months, he's falling behind and he's already risking liquidated damage. And 10% loss is a huge hit for contractor, and it may just wipe out his margin or render the project a loss for him. So what he will do, normally then we go through this dilemma, the vicious circle. The contractor will normally resort to EOT claim and often with an eye on prolongation cost recovery. So he wants EOT and he wants prolongation. And the practice is get the time first and the money will follow. So what the employer will do is he will try to avoid any EOT or prolongation cost. The dilemma also comes for the engineer, the consultant, balancing the role of the consultant or the certifier. They certify all the claims and the assessments. It's a delicate undertaking, as we know. He or she is paid by the employer to safeguard his interests. But at the same time, of course, all the duty for professional honesty, duty of care and fairness towards both the employer and contractor. It's a very delicate situation for consultants. So can or must always the engineer objectively maintain neutrality and impartiality? Intuitively, we say yes, of course. But in reality, sometimes these things, becomes an issue. The third part of my presentation is the common issues encountered in the LD and EOT assessment. Normally, we see employer engineers reluctant to issue substantial completion or final completion certificate to the contractor. Payment delays and delay in releasing retention money by the employer normally is inherent in these type of disputes. Then the contractor, if he doesn't have a remedy for payment delay, what is his remedy now? In Qatar, there's a practice that unless the contract expressly said otherwise, the delay in payment terms can be added to the EOT for the contractor, and sometimes with compensation. We also see that in majority cases of the completion delay dispute, there are elements of concurrent events from the employer and contractor causing the delay, and of course we don't have time to go through this more of concurrent, a bit complicated issue. We also see contentious and conflicting work schedules and programs, and we see also sometimes at times that parties really manipulate the program, the schedule, because they are at the end computer generated. So this is also the experts, the assessors have to be careful with. We also see issues with non-compliance with contractual condition precedent, a lot of and time bar. Most of the contracts, especially if you're looking at physics, they have a time bar for contractors to claim application, to submit the application, and also for the consultant employer to reply. As we mentioned, there's also some objectivity and professional neutrality of the engineer certifier comes in the question. Sometimes you see ambiguous and uncertain liquidated damage clauses where you don't know what the party's intention was, and how to estimate the LD is becomes an issue. You also see in contracts where LD is specified and hefty LDs are specified, but then there is no EUT clause in the contract. So there's no like a room for the contractor to the provision to submit application for EUT. So that also becomes an issue. Then, of course, if the contract, the dispute takes few years, and then there's also some missing projects, meeting records, and sometimes the parties are slow in producing relevant documents like consultants evaluations or design and drawings and emails and correspondence. The fourth part of my presentation is for those attendees who are probably not too familiar with Qatar's education and dispute resolution or construction, is a brief discussion on how things are conducted in Qatar. In Qatar, there's no statutory adjudication ADR for quick resolution of project ongoing construction dispute. For example, in UK, the contractor can, for example, submit the dispute to adjudication while the work is still ongoing. You know, in Qatar, we don't have that flexibility. And also, item 2, project is not very common to have project adjudication board in common practice. For example, for the contract, this is a standard dispute resolution, but most of the federal contract in Qatar, this provision is normally not included. So what options available for adjudicating a dispute? It's either go to litigation or arbitration route. That's why, because dispute normally stay to the end of the project, and or after the project, then you have a bundle of interrelated disputes coming to the litigation or arbitration. In the court in Qatar, usually appoint a Ministry of Justice registered subject expert to assess the claims and determine damage and remedies. The court expert determination is not binding. It requires the final court approval. The court is not obliged, of course, to go with the expert determination in Qatar, but in majority of cases, the expert report is endorsed by the court. The newly established Court of Investment and Trade is not compelled to appoint only Ministry of Justice registered experts. The court is also expected to activate mediation as an ADR in the near future. When the arbitrator is not an engineer, he will need also to rely on expert witness and mostly appointed by parties, but the arbitrator and tribunal can also appoint a neutral expert, as we all know. So the bundle of the claims that I mentioned, that eventually they all accumulate, but when eventually the dispute comes, as I said, all of these, most of these, you have in one claim, one case. Completion delays, defects and related damages, payment delays and quantum, contract breach, whose fault, contract termination, what are the grounds that determine the contract was terminated, performance bank or personnel, check guarantees, always some kind of an issue there with this type of dispute. Other damages suffered by any party besides the liquidated damage, then the experts for the court here, in case this is a litigation case, will reconcile the final claims and remedies quantum between the parties and submit a recommendation to the court. Ahmed mentioned on the case law authorities in Qatar and how the liquidated damages are handled. Briefly, I will just summarize what is the outcome that Ahmed already summarized. In Qatar courts, Qatar courts honor parties' agreement and intentions to include a pre-estimated LD in their contract. So they agree to decide to include an LD, the court will honor it. And of course, we say العقد شريعة المتعاقدين. Pacta sunt servanda. I mean, this is common and this is very respected. Parties can agree by their will what they want to include in the contract. However, contract genuine LD, as we said, will be applied. However, the court may waive or reduce the amount of LD if contractor can prove. Now, the burden of the proof is here on the contractor to show that the owner did not suffer damages, or the contractor partially completed the work, and that the owner himself maybe caused the delay. And of course, it has to be shown that the LD was not highly exaggerated. Courts also may award higher damages, larger than the liquidated damages, if owner, now the burden of proof here becomes on the owner to prove that the contractor's work was, included, inhibited fraud and gross negligence caused him excess loss not covered by the pre-estimated LD. There's one interesting case authority in Qatar that I probably need to bring it up if there's time. This cassation case 18 for 2009, where the Court of Cassation upheld the Court of Appeals decision not to award an LD to the employer because the employer had earlier requested the court to terminate the contract. And that's interesting. I don't have another update authority to 2009 from Qatar, but in UK last year, the Supreme Court ruled in the case of Triple Point Technology versus PTT that even if the contract was terminated, the contractor was still liable for liquidated damage if liquidated damage was established before the termination. So some suggestions, my final part of my presentation will be some suggestions how to enhance the enforcement of predictability of liquidated damages. So LD clauses must be very clear and ascertain and predetermined liability of the contractor. It has to be very clear and very specific. In projects that you have process and also construction, separate the DLD, the delayed liquidated damage from process liquidated damage. And the clauses for these two separate liquidated damages must be very clear and very well drafted. Also, the contract must show how to handle the treatment, how to treat the LD in event of contract termination. As I mentioned, the authorities in Qatar, all the authorities may have some issue with this. If we go with the UK recent authorities, as we said, the termination, even if you terminate the contract employer, the LD might still be applicable. Again, as we mentioned before, that LD, as Ahmed and the Senator mentioned, that the LD liquidated damage needs to be seen as a reasonable compensation for the owner and not seen as a penalty on the contractor. Whenever there is an LD in the contract, you need the balancing EOT clause in the contract. They have to go hand in hand with the LD clause. You cannot have LD and there's no EOT. There might create an issue. Also, the contract should be very unambiguous, should be very clear on the clauses on availability of additional remedies for genuine damages beyond the liquidated damages period in the event of contract termination. So other contract termination becomes a little bit complicated the situation. The contract has to be very clear on how the parties intended to handle it. So as we said earlier, remedy clauses for delayed contractor payments. One way could be to add it to AOT. And there's very common in Qatar, unless the contract specifies otherwise. Especially the parties express different methods. So that was my last presentation, and thank you for attention. Back to you, Saad.
Thank you so much, Engineer Abduljabbar. As usual, it was a very nice illustration from you on the expert point of view. So please stay with us. We will be taking the closing remarks from Professor Abdel Wahab. Then we will be starting the panel discussion. So Professor Abdel Wahab, let me again introduce to you Professor Abdel Wahab. Professor Abdel Wahab is one of the most well-known arbitrators in the world. He is the head of the International Arbitration and Zulfiqar and Partners law firms, and he is the C.Arb MENA trustee. Also, he's a professor of the International Arbitration, Private International Arbitration Law and English and Contracts Law at Cairo University. He is the founding partner and head of International Arbitration and Construction and Energy Group at Zulfiqar Partners and Law firms in Egypt, and also the ICCA Treasury and member of the governing board. And in addition, the Dean of the Africa Arbitration Academy. So Professor Abdel Wahab, please, the floor is yours.
Engineer Hegazy, I'm very grateful, and apologies for joining late. I just ended up a hearing, and I'm delighted to join. I'm grateful for the invitation alongside esteemed colleagues. I see Dr. Nasser is there, Engineer Abduljabbar, Mr. Ahmed, Mr. Saad, and a lot of colleagues who have joined this event, which is, I must say, a very important one, tackling a very, very interesting issue that pretty much surfaces in all construction arbitrations. My task is easy and difficult. Difficult because I have to make concluding remarks, including on aspects that I've not heard, because I joined only when the hearing concluded, but easy because you've had similar presentations, absolutely brilliant presentations by outstanding speakers. So that makes my life easier. I can simply say I concur and I agree with all what has been said. But that would mean that I'm not going to add my 2 cents. Let me say the following. I will summarize my concluding remarks around 6 specific words: what, when, where, how, who, and why. Each one of those remarks, hopefully without repeating all the excellent contributions made by others, relate to LDs. And I very much valued the concluding remarks and tips shared by Mr. Ahmed Habib and Engineer Abduljabbar Saifuddin, because I think they strike a chord actually in relation to LDs. But let me start by saying that what I'm about to share with you in relation to those 6 words in the remaining minutes is pretty much premised on what we see in practice and what tribunals are grappling with when it comes to LD's claims in arbitrations. So I'm afraid I'll probably leave you with questions rather than answers, perhaps which would induce and provoke a discussion during the Q&A. So one important thing is the characterization element, which is the what question. What are LDs? I'm not going to lecture you on things that you find in books, but I say it is in some cases an issue whether the tribunal looking at a clause would characterize it as an LD or not. And this goes to Mr. Ahmed Habib's point about proper drafting of LD clauses, and the same mentioned as well by Engineer Abduljabbar. And I'm sure Dr. Nasser in his opening remarks made excellent comments in this respect. Whether they are quantified, amounts to be paid, or quantifiable, or a penalty, or simply a statement asserting a party's right to be compensated. There are varying degrees and varying approaches to drafting these clauses. And my advice is that take good advice as to drafting those clauses to ensure that you either have quantifiable LDs that are reasonably reflective of the specificities of the contract and the harm or loss that could be sustained. If not, then make sure that at least there you have markers and parameters to be able to quantify them. There are some cases where we've seen in contracts drafted in Arabic reference to penalties, as in gharama, and they call it then LDs. And that brings about a myriad of disputes as to whether tribunals are authorized to grant that in the form of compensation, irrespective of the label ascribed to this by the parties or not. So characterization, which is the what element, is important. Secondly, when is another aspect that should be considered, which means when are LDs due in a way. It is again not uncommon to have a multitude of relationships where employer, contractor, and contractor, subcontractor. And in many instances, we run into arguments that is back-to-back contracts and whether a contract qualifies as a back-to-back one or not. And so one needs to consider when LDs would be due. The easy answer is to say, well, if there is a delay beyond the completion date, that immediately triggers a right to an LD. There are so many subset of questions about the reasons for that delay, who's responsible for it, and that goes to attribution, about whether that delay is compensable or not, whether a back-to-back provision is triggered, and even with the existence of a back-to-back, the element of culpability, which is you can have a back-to-back contract, nevertheless, the contractor remains liable vis-a-vis the employer, but the subcontractor is not liable for the delay vis-a-vis the contractor because it was the fault of the contractor rather than the subcontractor, or perhaps even the fault of another subcontractor rather than the specific subcontractor that the contractor may bring a claim for LDs against. And the other question in that sense that relates to this, the where element, which is my third word, where, and where ties in to the points you've heard about the applicable law. Be careful when looking at LDs to consult and get good advice on the applicable law, because it's not a one-size-fits-all. It might be the case, for example, that Qatari law and Egyptian law are not far apart from each other. But for example, in the UAE, courts have an overarching discretion to revisit LDs, irrespective whether it is grossly exaggerated, minimum, or otherwise. In Egypt and Qatar, for example, you can't go above the agreed LDs, except in cases of fraud or gross fault, for example, and you wouldn't go below unless it is grossly exaggerated or partially performed obligations. So definitely the applicable law element is indeed important. And here I have to tell you something that tribunals, arbitral tribunals, also grapple with in non-common law jurisdictions where we don't have a strict doctrine of precedence. To what extent arbitral tribunals are bound by determinations by national courts in cases decided by those courts? They are submitted as legal authorities in arbitration proceedings, but is the tribunal necessarily bound by findings of that court as representative of the applicable law, or is it persuasive evidence that the tribunal can consider a different measure or a standard? That is one aspect that in international arbitration people grapple with. And the other point, my fourth word, is how. How would you go about awarding LDs? And this goes to Engineer Abduljabbar and Mr. Ahmed's point about experts. It's not anymore in construction arbitration that instructing experts is desirable or a preference. It is a requirement. you want to have a credible case, you need to be tested by an independent expert, and I mean really an independent expert, owing an overriding duty to the tribunal. And that expert would then engage in taking a measure of the LDs. And the evidence to support ideally are contemporaneous records, in a way, looking at EOTs, as Engineer Abduljabbar has mentioned, the causes of delay and attribution elements, which is the culpability that I referred to earlier. And then who can claim? Normally, we always label that the employer. Yes, but also a contractor in a subcontractor relationship is an employer for the subcontractor. So they can make a claim. And that's normally the easiest claim, because what would happen, easiest to make, but not necessarily to be awarded, because you can run a claim for delay or LDs. What you need to show is that you went beyond the completion date. And that would trigger a head of claim for LDs. But then that shifts the burden of proof to the other party, which is the contractor in the employer-contractor relationship, or the subcontractor in the contractor-subcontractor relationship, to disprove either there has been a delay or that the delay is not attributable to that party, the debtor, or that the delay is caused by the allegedly aggrieved party themselves, or that it is caused by a third party. In that sense, there are a lot available to prove. One thing that people tend to overlook is during a document production phase, you need to ask for the right documents to be able to substantiate your case on LDs, or negate it or defend against it if it is made as a head of claim. The particularization of the claim is indeed important, because it is not uncommon in some cases that we find the party entitled to bring a claim for LDs, saying that we're entitled to LDs, but there are no particulars for that claim, nor are they able to run it because the works are not completed and a final account has not been produced. And that creates another anomaly within the system and a challenge to the party running an LD's claim in that sense. And that brings me to the last aspect, which is the why. Why LDs? Because it is almost certain that in all construction contracts, people want the project not to go off track. They want that to be maintained. And time sometimes could be of the essence. The problem is construction contracts are a recipe for disputes. It is quite rare that one project would not go without having an associated dispute, which can either be resolved amicably or not resolved amicably and went to arbitration. And so when answering the why aspect, one needs to maintain proper records, needs to have a proper delay analysis to consider the causes for delay, attribution, before making quantum-related claims in that sense, and looking at the thresholds we mentioned as to whether a claim is exaggerated, grossly exaggerated, underestimated, or not. Because there is one principle that applies in almost all our legal systems in the MENA region, that is full reparation of the harm. And full reparation then brings about its own challenges, which is if you have agreed LDs in your contract, does that bar other elements of compensation on the basis that this constitutes the exclusive basis on which a party can be awarded LDs, or can you bring other heads of claim without running the risk of either double recovery or overcompensation? These are all challenges that tribunals grapple with. And counsel, and that's my 2 cents, is required to assist the tribunal navigate its way through the sea of documents, the voluminous record, and the counsel that will prevail is the counsel that gives the tribunal the easiest, clearest, and safest shortcut to reach a finding on liability and quantum. I hope I've not wasted your time, and I hope I've not exceeded my 10 minutes, but these are my 2 cents, and I very much look forward to the Q&A, and thank you very much for inviting me again.
Thank you so much, Professor. Actually, we would like to hear more than this 10 minutes, to be honest. We are getting a lot of knowledge just by listening to your outstanding closing remarks. But let me actually start with you on the Q&A. And one of the points you spoke about, number 3, which is where in regards to the applicable law. So basically, what do you think, what is the reason which is the legislators actually adopted different regimes pertaining to the LDs? For example, you mentioned Egypt and the difference between Egypt, Qatar and Bahrain in one hand, and Jordan, Oman and UAE on the other hands. So what might be the reason?
It's an excellent point, and hopefully without being biased, I will say the following. I mean, normally the oldest of these legislation is the Egyptian Civil Code. So we have the Egyptian Civil Code, we've had the provisions. Some of our MENA region colleagues have had faith in the Egyptian Civil Code and so adopted the provision in that way. Yeah. Others, in light of the doctrine and jurisprudence, have perhaps rightly even highlighted and considered that there are some issues that arise and require refining. So that brought about the Jordanian, the UAE approach, for example, whereby they thought that having a different approach without restraining the court or the tribunal's ability to look at the LDs, so that a court in a sense can consider whether this is in essence a proper estimation of the harm or simply a penalty. And if it is the latter, it would be denied. If the former, then yes. And so allowing the court and the tribunal the discretion without restraining this discretionary power between two parameters, that is grossly exaggerated. And remember, the test under Egyptian law and the Qatari law is grossly exaggerated. So one could stop and say, if it is simply exaggerated, still it does not prevent that being awarded, though tribunals will think twice because of the principle of full reparation. And then the other lower aspect, which is going above that in cases of gross fault and fraud, which in themselves bring a much higher threshold and standard of proof that may not be easily met. So that led some of those jurisdictions to say the legislative philosophy is that the court or the tribunal then has full discretion to assess the harm in light of the specificities of the case. But that, of course, brings about another philosophical question. If the courts are able to do that and not pay tribute to an LD's provision, what value then remains for a party's agreed LD provision if the court can simply disregard it? This, I think, are the two competing legislative approaches that exist in the region, and tribunals in arbitration are caught up between those two approaches, depending on the applicable law.
Thank you so much, Professor. I will be moving to the next questions. We have received plenty of questions. I'm sure that everyone is, I'm just gonna remind the attendees that we have like 250 participants and we have over 20 questions, so we will not be able to answer all the questions. However, you are welcome to contact the speakers later and they can answer some of these questions. And this is recorded session and we will be sharing the recording and the slides as well for people who has been asking this one. So let me go to Ahmed Habib and ask him a question from Eli Antonius. He speaks about how can the obligor proves that the obligee has suffered no damage? In other words, how can someone prove that the non-existence of something in case of the obligor claims that no harm happened? The obligee will have to make a counterclaim and quantify the actual harm, which render the LDs of the contract avoid, and the real value of the real damages should be considered. So please clarify.
Thanks, Saad, for the question, and thanks for the person that asked this question. It's actually a very good one. That's a real issue here about proving that something does not exist, right? This is the famous proof diabolica, which is very hard to do if it's not impossible. Let's say that in some cases, and I presented two case law as an example under Qatar law, in some cases, it's easier than in others. So in one of the examples that I presented, it was a subcontract. And the court based the idea that there was no damage for the contractor because it was subcontract. So no damage for the contractor because it was able to deliver the works in time to the employer. So it suffered no damage in this case because it didn't have to pay any liquidated damages or to compensate the employer for the delay. So this could be a simple case. In other cases, I completely agree with the person that asked the question. It would be more difficult to prove, but here it's a challenge that join the challenges raised by Professor Abdul Wahab. And then it's a matter of instance by instance. And also maybe it could be presented as a question to the tribunal in certain cases that it's very hard to prove in this case. But then, as Professor Abdul Wahab said, maybe there is a point to make since the production of document phase in order to seek to have some proof from the opposing party. So that's my answer on this point. And on the last part of the question, certainly whenever this point is raised, it would shift like the game of proof anyway, it would shift the burden of proof to the other party to prove that in reality it suffered damage. And that's how it goes. Everyone has to prove its position after that. Thank you.
Thank you so much, Ahmed. Please. Engineer Abduljabbar, I would like to ask you a quick question in relation actually to the Qatari courts. So do Qatari courts award delay damages if there was no LDs or general damage clauses in the contract?
I am in the presence of Professor Dr. Mohamed Wahab. So إذا حضر الماء بطل التيمم بس والدكتور ناصر أستاذ أحمد. أما بشأن هذا إذا السؤال إن إذا العقد أو I'm sorry I speak Arabic. If the contract
we have translation, so don't worry.
The contract has what you say inside the contract doesn't have LD and damages clauses in it. So I am aware of one authority that has happened. The contract is honored here in Qatar. Whatever the parties agree, the parties have to honor their obligation. Both parties, once they sign a contract, the obligation must be honored. So if one party is in breach, Qatar law awards damages. If the aggrieved can prove, the burden of proof is that he was actually got damages. There's no reward, there's no damages. I'm aware of one authority that was, and this was a rent agreement that in the industrial area that the authorities were supposed to bring like electricity power for the investment and investor, and it was late. For a few years they didn't bring him, and then he claimed damages and he was awarded. So I think yes, generally yes, I think it will be awarded.
Thank you so much, Engineer Abduljabbar. So
can I share with you an interesting case there?
Yes, please.
And I'm very grateful for Engineer Abduljabbar's intervention. One needs to look at three different aspects. The general approach is that you don't need a damages provision to be awarded damages in your contract, because the law provides if you have a fault or a breach that suffered a harm and you prove the elements of contractual liability, noting there is another variance in the MENA region, whether causation is presumed or not, because in some jurisdictions it is, in others it's not. If that is the case, then you can claim compensation under the law for a contractual breach. Now, the case I want to share with you was the following. The parties submitted evidence that during the negotiation of their contract, there was an LD provision that they fiercely negotiated, disagreed on, and excluded. So one party said, by excluding LDs, the common intention was an exclusion of liability clause, no harm, should be compensated. The other party said, no, simply we disagreed on the LDs. That does not bar my right under the law to bring a claim for damages. Witness evidence, lawyers battling this, and then the tribunal has to decide. Even so, in another case, they had a limitation of liability or exclusion of liability, and yet the party said, I'm running a claim for compensation because that limitation of liability clause or exclusion is either invalid as a matter of law, or because the harm I suffered is a harm for a gross fault. These again are examples of situations which happen in real life. Now, on the first example, I have to say, on the evidence, the tribunal found that even with the fact that there was negotiations on an LD and that the provision ultimately did not find its way into the contract, the tribunal could not read or infer from that there was a clear intent to exclude liability. If you wish to do so, you would include a provision on excluding liability, so it's not barred. So that's, again, just an example to share with you that sometimes what may come across as a very simple question may result in a fearless battle in arbitration.
Yeah, thank you so much, Professor. So let me move to Dr. Nasser, asking him about also the Qatari course, since we have the new course of the investment course. So, Dr. Nasser, can you tell us what is the approach of the investment course in this matter?
Yeah, thank you very much. Thanks. The new investment court, the new investment and the trade court, which is being introduced by law number 21 of 2001. All the cases of the construction disputes will go to it after the 30th of May this year. So there is a time bar to all the cases which to be submitted to the court to be after the 30th of May this year. And before that, it will be seen by the normal civil and commercial court, right? Regarding the liquidated damages clauses, I think that the Qatari courts in general, we don't have much judgment in my hand now. It was a new court. It is a new court. I don't have much judgment now. We have some cases we have submitted already. But let me speak a little about the previous civil and commercial court. We have seen there is some, let me say, overlaps between the understanding of the liquidated damages and the penalty. I think there is some overlaps on that from the judges themselves. Sometimes they think the LDs are penalties. Sometimes they think the penalties are LDs. And sometimes they are mixing that with the unliquidated damages. The distinction between the liquidated damages and penalty for the previous civil and commercial court, it's like when you ask the non-expert, the people in weather, what is the difference between weather and the climate? So you might find some difficulties in making the differences between the two. But I am very, very keen to see what is the approach by the new investment and trade courts. I am also keen to add one thing to my colleague Abduljabbar. Abduljabbar stated that there is a Ministry of Justice witnesses, but I would like to add one thing, that each party shall bring their own expert witnesses as well, and to submit their reports with either the claim or the defense of the respondent. And I think this is what I have said.
Thank you so much, Dr. Nasser. I'm not gonna make this more longer. Just last question to Professor Abdel Wahab, because it's actually a pleasure to have him today among with all the distinguished panel and distinguished speakers we have. I have a very nice question, actually has been asked by Joe Kelly. We have received like 50 questions, so we cannot answer all of them. So in respect of liquidated damages, which were calculated during different economic circumstances, for example, the sales projected sales value at completion. In practice, the sales value may increase and the employer may not suffer losses. So how is this catered for?
That's an excellent question, but let's say the following. LDs are a remedy. You are not engaging in a negotiation that may result in considering changed circumstances. It's a valuation of the harm. Now, if the ensuing situation leads to a scenario where it is arguable that no harm has been sustained, then it is for the debtor then, which in our case could be either the contractor in the main contract or the subcontractor in a subcontract, to prove the no harm. And it goes back to Ahmed's point about the difficulty of proving the negative. But you can simply try to evidence that by different ways. If the delay did not lead, for example, in a subcontract to any LDs under the main contract, and it's back-to-back, then one would not expect LDs to be payable. Otherwise, it could be a windfall. If there is issue with liability, as I mentioned earlier, that the debtor is not liable, then that is, again, an element to disprove. If the idea is that there's no harm suffered, again, that goes back to the point, which is basically no LDs will be payable. LDs are not intended to be a windfall. It is not an approach where a party can make business out of it. It is intended to remedy a harm. Absent a harm and a loss, no payment should follow. The question is one always of proof. Can you prove it or not?
Perfect. Thank you so much, Professor Abdel Wahab. And actually, we came to the end. Actually, I don't want to finish it. I'm feeling also all the attendees actually enjoying it. We have more than 200 people still here, but we have to end it sometime. So thank you so much for the panel. I would like to thank Dr. Nasser for hosting us today on the C.Arb. I'd like to thank Engineer Abduljabbar for coming and speaking today for us. Also, I would like to thank Ahmed so much for his presentation and thoughtful thought, and thanking all the attendees who attended today. I just remind you that in the C.Arb, we have various programs, we have various trainings, we have various membership level. So please approach, if you are not member yet, please approach one of our colleagues or myself or even the administration team to see how you can enroll in the C.Arb today. And also in AACE, sorry, Dr. Nasser, because also I'm representing the other side. We have various memberships and certificates we can also promote for it. So please also approach our team, our local team, and we will be always having the pleasure of having you today. So without saying further, so have a good night, and thank you all for attending today. Thank you so much.
Thank you very much. Thanks.
Thank you. Thank you very much.